These include addressing the issue of homelessness and temporary accommodation. But it's always the duty of the social authority to ensure that all children grow up in secure and good condition, and they should therefore take measures if they have reason to assume that the child needs support or protection, regardless of whether or not this child is resident in Sweden. An important task for the social service is also the outreach work related to vulnerable EU citizens in order to avert acute emergency situation for girls and boys, women and men. Most of the EU citizens who beg in the street in Sweden come from Bulgaria and Romania and do not have a European health insurance card. The basic assumption then is that they have to pay for their own health care cost. But in April 2015, the Swedish National Board of Health and Welfare published information on its website explaining that vulnerable EU citizens could also occasionally be covered by the Health and Medical Care Act when they stay in Sweden more than 3 months without the necessary resident permit. They should then be considered as persons staying illegally in Sweden. According to the Health and Medical Care Act, persons who stays illegal in Sweden have a right to health care that cannot be postponed, and children should have the same right to health care as other children. Romania and Bulgaria have, just like Sweden, compulsory school for children. The school activities in Sweden is governed by a number of laws, and according to this, the children have not the right to education if they are not living here. But nothing stops the municipality from offering teaching to children. But from what the most people, parents here are here temporary and have no plans to move to Sweden. However, if families are actually living in Sweden, they have the right to education. Swedish legislation will apply to all, and nobody is allowed to live more than just 1 or 2 nights in a park, other public spaces, or on private land. The enforcement authority has their regulation and law according to forced eviction. Last year there were around 230 applications for forced eviction from illegal settlements. And the government is of course very concerned that people living in severe poverty in their home countries, and then the fact that they then come to live in inhuman condition in our country. There are other actions too. The civil society have the gap between the municipality, social service offer, and the need of the group of vulnerable citizens give both NGOs and the church the opportunity to help. Both traditional organizations achieve and new association and network are formed, and that is very positive. Begging not a crime in Sweden, and the government does not intend to change this law. The government does not believe that the solution is to use crime law against people in need who ask others for help. The government both wants vulnerability and begging to be reused, and in the long run not exist. Thank you.
Thank you. Distinguished committee, turning first to the question posed by Mr. Shaney on signals intelligence, we have been provided with further information from the Ministry of Defence as well as the National Defence Radio Establishment. There are no provisions specifically regulating the concept of data mining in the Swedish Signals Intelligence Act or other acts and ordinances regulating the surveillance. However, there are several acts and ordinances regulating the area, and The intelligence activities of the National Defence Radio Establishment are carried out through collection of data, followed by processing and analysis of this collected information. There are comprehensive limitations on the operations of the National Radio Establishment. The operations must only be carried out in certain purposes laid out in legislation, for example, to map foreign military threats against the safety of Sweden. Signals intelligence must be targeted at certain specific signals identified through specific search terms. These terms must be identified while fully respecting the right to privacy and to ensure that the intelligence operations limit the intrusion into the private sphere as far as possible. Terms aiming at specific persons may only be used if they are of great importance to the operations of the National Defence Radio Establishment. All operations must be authorized beforehand by the Foreign Intelligence Court. The court may only authorize signals intelligence if certain criteria are fulfilled. In the permit for surveillance, the purpose of the operation, the signals bearer, and which terms that are to be used must be specified. The legislation is put in place to ensure a balance between national security and the individual's privacy. On the statistics on the Foreign Intelligence Inspectorate, it is the main supervisory body on foreign intelligence and signals intelligence. And the Inspectorate has an obligation to check if persons have been subjected to intelligence operations, and if so, if the operation was carried out in accordance with law. The Inspectorate must also inform the person that the surveillance have taken place. In 2014, the Inspectorate carried out 12 checks requested by individuals. This is in general the same number of checks that have been carried out in the years prior to 2013. During 2013, however, there was no less than 62 checks carried out. This large increase is due to heavy media reporting on the possibility to have such checks carried out. The operations of the Inspectorate and other oversight mechanisms are reported annually by the government to the Parliament. On the question on Protocol 12 and the Discrimination Act, the Swedish Discrimination Act has a prohibition of discrimination on 7 grounds. There are currently no plans on reviewing the possibility of having an open list and for the ratification of Protocol 12 on the Convention. Regarding the regulation on the crime of illegal discrimination in Chapter 16, Section 9 of the Penal Code, there is also no intention to amend the Penal Code in this regard at the time being. On Mr. Fatala's question on resources, and in addition to the remark of the State Secretary on the increased funding, the Discrimination Ombudsman's total budget comprises of 108 million crowns annually, and the local and regional anti-discrimination bureaus and offices receive state funding to the tune of approximately 14 million crowns annually from this year onwards. Thank you.
Microphone for the speaker, please.
Sorry, so I start again. Regarding the follow-up question to the previous question on Mr. Assange, I have interpreted it as a question on the Swedish European arrest warrant system and its procedural safeguards. In the Swedish procedural system, there is first a request of detention by the prosecutor to the courts. Then the district court needs to assess whether there are probable cause for the suspicion of crime. The decision can be appealed to the Court of Appeal and further to the Supreme Court. It is only after such court proceedings that the prosecutor can issue a European arrest warrant. Thus, the Swedish government holds that the Swedish European arrest warrant procedures contain sufficient safeguards. To reply to Sir Nigel Rodley's follow-up question regarding the new guidelines of the Swedish Prosecution Authority, yes, they are in the public domain, and I will try to give you a short description of the content. So in January 2014, a working group submitted the report Pre-Trial Detention Periods and Restrictions. The Swedish Prosecution Authority has subsequently produced guidelines concerning restrictions and long periods of pre-trial detention and regulations and general advice on restrictions. And in summary, these guidelines, in force since 5th of May 2015, make it clear that in each individual case there has to be a careful assessment of whether there is a considerable risk of the suspect impeding the investigation, that is risk of tampering with evidence. And if there is such a considerable risk of tampering with evidence, the guidelines state that the prosecutor has to examine whether this risk, in relation to the gravity of the offence and the intrusion or other detriment that the measure entails for the suspect, in itself justifies deprivation of liberty. Where the risk of tampering with evidence cannot independently justify deprivation of liberty, the risk of tampering with evidence is not to be invoked as grounds for detention. The guidelines also make it clear that prosecutors, when deciding whether to impose restrictions, are to take a position on the necessity of each individual's restriction, and for each restriction to outweigh the risk of tampering with evidence and the gravity of the offence against the intrusion or other detriment that the measure entails for the suspect. In those cases restrictions have been imposed, the guidelines also make it clear that the grounds for the restrictions are to be continuously re-examined. Thank you.
Thank you. Good morning, everyone. Turning first to the additional question by Sir Nigel on the all-party committee of inquiry, the task of considering whether an independent body should scrutinize the activities of both the police and Swedish prison and probation service. I quickly looked into my machine, and I would be happy to provide an English summary of the inquiry to the committee in an appropriate way, if I could mail it to the Secretariat in order for the committee members to have a more detailed understanding of the remit of the committee and its proposals. Basically, they are proposing the establishment of an independent joint agency under the government to scrutinize both the police and the prison and probation service. Now, this has been assessed against the background that we have quite a supervisory machinery already in place. And in particular, the Justice Ombudsman is very active in scrutinizing and assessing also specific cases which serves as guidelines for the police and indeed the prison and probation service. But I'm happy to provide a summary of the public inquiry in English. It's quite extensive to be a summary, in fact. Turning now to Monsieur de Frouville's follow-up questions. While I mentioned yesterday that the point 64 in our written response was not a miracle of clarity, and I remain and I stand by that statement. But in order to simplify the division between how the complaints against police officers are handled, I would refer to the normalization principle. Any complaint against the police officers for using excessive force in the line of duty has to be scrutinized by a senior prosecutor within the special organization set up for this. If there is a suspicion of a criminal offense being committed by a police officer, then a normal criminal procedure should take place, albeit that the special investigation department of the police will investigate this under the guidance of the special prosecutor organization established for the purpose. So once there is a suspicion for a criminal offense, there should be a criminal proceeding. However, there are also other types of misconduct and bad behavior from police officers sometimes occurring, which may render them disciplinary sanctions. And this is dealt with within the Special Investigations Department and ultimately being decided by the disciplinary board of the police. I hope this simplifies the thing. I'm ready at any moment, at any time, to provide a more clarifying response in writing if you so wish. Turning to the two specific cases raised by civil rights defenders, I wish first of all to say that we very much regret 2 persons have died as a consequence of use of firearms by the police. This is obviously nothing that we are happy about. As I mentioned yesterday, we are trying also to address the number of cases where the police have to use firearms in order to pursue their duties. Now, I understand now that the case concerning Mr. Mern is the subject of an individual complaint submitted by the civil rights defenders, and therefore I should not comment further on that case. Also, in the case of Mr. Selvaraya, I understand that the criminal investigation is now reopened, and that also leads to the conclusion that I should not comment on the case until the criminal investigation is finalized. I will be happy to report to the committee about the outcome of, in particular, the case concerning Mr. Selvaraya. The other case, I think, information will be provided in any case. Thank you.
Distinguished head of delegation, Swedish delegation, could the interpreters kindly ask you in your answers to speak at a measured pace to ensure accurate conveyance of your message into the other languages? Thank you for your understanding.
Yes, thank you. Thank you, Mr. Froville, for letting me getting back and try to expand on the issue of ECT, because as the same problem as Mr. Sjölinder has, this answer number 66 could be clearer. This might be a bit medical, but I try to keep it as short as I can, but try to give you a comprehensive picture of ECT, how ECT is used in Sweden. So ECT is electroconvulsive therapy, not electroshock therapy. It used to be. And it's a psychiatric treatment in which seizures are electrically induced in patients to provide relief from psychiatric illness. ECT is generally used with informed consent as a last line of intervention for major depressive disorder, mania, or catatonia. ECT works best at difficult, deep melancholic depression and has proven stronger and faster effects than medication, which is of great importance in the presence of severe symptoms such as suicidal thoughts and hallucinations. There are clear guidelines for carrying out this treatment worldwide, basically, but in Sweden too. And in Sweden, the Swedish Psychiatric Association presented clinical guidelines for ECT in 2014, very comprehensive. The guidelines defined a number of established indications for ECT, in addition to severe depression included inter alia manic episodes associated with bipolar disorder or schizoaffective disorder, schizophrenia, cycloid psychosis, and postpartum psychosis. The Board of Health and Welfare published specific guidelines on ECT on the matter of informed consent in 2011 after making review of benefits and challenges with ECT treatment in Sweden. ECT in Sweden is always prescribed by a psychiatrist. In the clinical guidelines, it's recommended that clinical psychiatrists shall be responsible for ECT treatment, but treatment is performed in teams, and those teams are quite big because the patient is sedated during this treatment. And as I told you, since 2011, Sweden has National Quality Register on ECT treatment, and we have a coverage of 89.3% of all treatments carried out in Sweden. And as I told you yesterday, it's individual-based data on health problems, what caused the treatment, actions taken, and outcomes. So we actually know quite a lot about the outcomes and the indications in Sweden for carrying out ECT. So we do know that in the last published report on 2014, the register included 4,103 patients, of whom 63 were women, and that is a fact probably linked to the fact that depression is much more common in females than in male. We also know that the most common clinical indication for ECT was depression. About 80% of the patients treated was for depression. We also know that 45% of the people treated with ECT in 2014 reached complete remission, 76% improved, and 0.3% of treated patients got worse or much worse after ECT treatment. 17% suffered from memory impairment as a side effect. I also, just let me finish with, I also forgot yesterday to tell you about the Health and Social Inspectorate's role in this. And this is a government agency responsible for supervising healthcare, all healthcare, including ECT and everything else. And the Health and Social Care Inspectorate supervises all healthcare, yes. The agency has an ongoing review of ECT, of course, and targeted as late as in 2014 criticism of a healthcare provider for performing ECT bilaterally as a first treatment. So that is the short version of, but still, I hope, makes it clearer than it was before. Thank you.
Mr. Chair, thank you. We hope now that we have been able to answer the follow-up questions in a satisfactory way. Tried to be brief, yet still as specific as possible. We are now ready to and look forward to continue this dialogue with this distinguished committee on the remaining list of issues. Thank you.
Thank you very much, Head of Delegation. Now we will go straight on to the next section, the second section of the list of issues. I have great pleasure in giving the floor to my dear colleague, Ms. Ivana Angelika, who has the floor now. Thank you.
Good morning to all. First, I would like to thank the distinguished delegation of Sweden for constructive and open dialogue. I appreciate your answers, replies to the list of issues, which is very detailed concerning paragraphs, issues 15, 16, and 17. Today, my interest would be especially regarding those issues and issue number 14. In respect to equal rights of men and women and non-discrimination of women, which is covered by issue number 14, I was glad to read that the government decided to commission the National Mediation Office to analyze the design of the central collective agreements from a gender equality perspective in 2015. What are the results of the analysis? Is it available now? Let me just emphasize this because according to Swedish national law, having in mind that EU law is an incorporated part of Swedish law, the principle of equal pay for men and women for equal work or work of equal value, today contained in the Article 157 of TFEU, has been entrenched ever since the beginning with the EEC Treaty. And in order to facilitate the implementation of the principle, two directives, one from 1975 and the recast directive from 2006, number 54. So indeed, both direct and indirect discrimination in pay are prohibited. And also, the Court of Justice of the EU has answered many preliminary questions of national courts on this issue. I know that within the European Union, women earn on average 16.3% less than men, which is official data, and that the progress has been slow in closing the gender pay gap. Please, can you provide the committee with the statistics concerned in regard to Sweden, if any? And also, my concern goes in line that the concept of pay, as contained in the recast directive, is not defined as such in Swedish law. Concerning national law explicit prohibition concerning direct and indirect discrimination on the ground of sex with regard to all aspects and conditions of remuneration, It is not a national legal system that provides such explicit stipulation, and it seems that actually the regulating pay discrimination in Sweden could be estimated far from transparent. This is from some experts' opinions at EU level statement concerning the justification for pay differences. It is actually left to the courts to decide to the end on this issue in Sweden, and I believe this should be regulated by law and collective agreement. And I would be particularly interested in improvement in this regard, because that would ensure legal certainty. Concerning another aspect of equality between men and women, and it is connected also with some of my questions from yesterday, but I decided to ask it today because it is directly connected with equality principle, gender equality. And I would like to ask what was not emphasized in your replies and what is positive fact in Sweden is that Sweden is among those very few European countries defining the concepts of sex and gender. And I was glad to read it also in Chapter 1, Section 5.1 of the Swedish Discrimination Act. This is very positive development, I would say. Broader concept of prohibition of discrimination due to gender reassignment is also covered in Swedish law as a part of a broader prohibition of gender identity discrimination. However, in some provisions, the Discrimination Act is not transparent enough. For example, it is not explicit if the ban of direct sex discrimination covers also pregnancy and maternity discrimination. According to some opinions, implicitly it is covered and it can be criticized on the point as not transparent. And having in mind the fact which we emphasized several times, several colleagues of mine and me also emphasized the fact that Discrimination Act is not harmonized with European Convention on Human Rights, it is problematic actually which body is to give the final word on this issue on maternity and pregnancy discrimination, because Equality Ombudsman does not have that competence according to Discrimination Act. So the courts, I suppose the courts are those bodies to give the final word, but no available case law. So if you can update us on this, if you could provide committee with more information on the figures of reported cases as well as solved cases in regard to discrimination based on pregnancy and maternity, I would be very, very glad. Concerning issues 15, 16, and 17, I would like to thank you for detailed answers. I would try to be as brief as possible. I have several follow-up questions and I pay attention to our time. I would like to say that amendments of the legislation on sexual crimes from 2013, as well as accession to the Council of Europe Lanzarote Convention same year, as well as new act implementing EU directive on combating the sexual abuse and sexual exploitation of children and child pornography are positive developments. But my question is, has the situation in field, the situation, has it been improved in regard to violence against women and the children, especially domestic sexual violence, marital rape, and violence at work? And if you can share with us statistics concerned, it would be very useful. It was also positive to read that in 2014, the inquiry was appointed to review the penal provision and consider whether the criminal liability for the crime is appropriately drafted or whether there are reasons for amendments. What are the outcome of the report? Since the report was to be presented last June. If you have update on this, that would be useful as well. Concerning issue 16, it is visible that the state party undertook a lot of measures in order to face the problems of trafficking of persons and related issues. Although it is known that the inquiry report was due yesterday, to be reported yesterday, if you have any updates concerning a review of the scale of penalties for purchase of a sexual act from a child, it would be also useful. Having in mind the measures which were undertaken and described in point 98, what are further plans in this regard? If you can share this information with us, it would give us a broader picture. I would be interested in the statistics concerning the investigation on trends in prostitution, which is followed since 2013, as reported. And also concerning point number 100, concerning the action plan for protection children from human trafficking, exploitation, and sexual abuse. Has the action plan been assessed so far? And what are the concrete results, measurable effects in practice? As you reported, in the period from 2007 to 2014, the training programs for staff in justice system, police, prosecutors, judges, were undertaken. And I would be interested if this is ongoing process or are there intentions for its continuation as a good practice and needed practice, I would say, having in mind the situation in field. My question concerning the County Administrative Board in Stockholm, its commission, what has been achieved in regard to developed programs of support for rehabilitation, which was described in your report, since 2014? So if you can be concrete as much as possible, that would help committee a lot. And concerning issue 16.f, connected with the children or child sex tourism, the campaigns that were carried out in Sweden from 2011 to 2012 and in 2014 are very positive, but if you can explain a little bit more, elaborate on National Bureau on Investigation, can you be more concrete concerning the results of the program that has been very positive? So what exactly positive results mean here? Because it's descriptive and there are no concrete information on that. And finally, issue number 17. concerning measures undertaken on protection on foreign workers employed in berry picking sector and protection from labor exploitation and discrimination. I would like to ask you, after the police trainings that happened in 2013, was the situation in field better? Was it improved now? Is there available statistics on that, especially on labor exploitation, inadequate living conditions, criminal offenses and activities, or any other abuse of rules on labor of immigrants and exploitation of workers from third countries? Because, of course, in Sweden, EU citizens are not treated as third countries workers, and as far as I could see, their rights are better covered and better protected than of migrant workers. Concerning National Homeless Coordinator appointed in 2012, it would be also useful if we could get any concrete data or reports on results of the coordinator. And finally, I would like to tell that we appreciate your details, answers, and in advance, I thank you for your further replies on this matter. Thank you.
Thank you very much, Ms. Shelik. Maintenant, je passe la...
Now I'll give the floor to Mr. Olivier de Fouville. You have the floor, sir. Thank you very much, Chairman. This morning, I would like to concentrate on the issues 18, 21, and 25. So I'll start with 18, issue 18, which was already covered a little yesterday. We had some answers on this issue. So it is the issue, the issues related to refugees and asylum seekers. In particular, the practices for sending back refugees. Now, several colleagues mentioned that Sweden is the country in Europe which has the most open policy towards refugees alongside Germany. And from this point of view, I think we can certainly congratulate you on this policy that has been in place up until now, which has been faithful to the memory of Olof Palme. Some 60,000 migrants have arrived from Europe, and this is important for us to remember. And the delegation has concentrated on that, and in the introduction we heard that the crisis doesn't just affect Sweden but all of Europe, and that the response that is expected is above all a European response with solidarity from all the members of the European Union, bearing in mind the principles of the European Union and that it is not merely an economic union. So I think that in this case we can say that Sweden has shown the path to follow, whilst it is clear that they cannot deal with this alone. Another part of the problem is the fact that Europe has a crisis of migrants. It is the case that the migrants are faced with a crisis which leads them to leave their countries of origins. So the responsibility lies also with the responsible management of the crises in the countries in the Middle East. So I think with the details that we heard from the minister's presentation of the Act on Reception, which came into place on the 1st of March 2016, where all communities can be asked to take in migrants, I think it's a very positive measure, because we see that in some countries communities and municipalities do not rush to organize themselves for the reception of immigrants. So I think it is a measure that is very welcome. You've also indicated that measures have been taken, and I was very interested to hear this statement, that measures have been taken to facilitate the integration and access to work for migrants. Could you perhaps give us some more information on the character of these measures so that are being made to facilitate integration on a local level? You also explained, and I think it was mentioned again yesterday, that a provisional 3-year measure has been implemented with temporary permits to stay with assistance. The issue of family reunification was also mentioned within this context. I'm not certain that I fully picked up on the answer, and I wanted to ask on that within this statute, the provisional status that will be given to refugees with subsidiary protection. Is family reunification possible within that, or will it be excluded? That's an important detail that I'd like to hear. A study came out yesterday on the announcement in January 2016. I think the Home Office that some 80,000 would be coming, and the potential use of detention of deportation of migrants. Now, the number is not surprising, because if we look at the number of migrants in the territory, but the alternatives to detention and the control measures are rarely used, and it is detention which is most used. And I wanted to know if that was exact in terms of the facts, and if it is the case, why is priority given to detention? So that is the issue on 18. Now I'll move on to 21, which covers unaccompanied minors. The issue was already mentioned yesterday, but I just have a few other questions.
These questions relate to some additional points. Issue 21 relates specifically to the termination of the European Return Platform for Unaccompanied Minors. This was a noteworthy experiment with a Phase 1 and Phase 2 with EU funding, bringing together various EU countries, including Sweden, with the purpose of organising the return of unaccompanied minors to their country of origin on a voluntary basis, with a view to ensuring that those children can be returned and received by their country of origin in a safe, dignified way with proper respect for their rights. This pilot came to an end in 2014. This is mentioned in your report, and you offer an assessment. Am I to conclude from this that the experiment was a failure, and as such was not continued? If that is the case, what lessons has Sweden drawn from this pilot, vis-à-vis, in particular, its current practices as part of its work to return unaccompanied minors to their country of origin? In addition, what conclusions can you draw from this pilot program with regard to Sweden's and various other countries' view on the notion of internal asylum and the possibility to be safe in one's country of origin, but in a country different from that from initially came in the case of unaccompanied minors. Do you have the impression that this notion of internal asylum is something that's worth exploring further and is useful? Or do you consider that the failure of this pilot program signals the failure of this notion of internal asylum also? Another point that has not yet been sufficiently discussed but is particularly problematic in Europe as a whole, but particularly in Sweden, is the fact that some minors are missing, either because they reach the age of majority 18 or because they are in a legal limbo or outside of the official assistance safety nets. Various concerns have been raised as to the possible capturing of these unaccompanied minors outside protection networks by people trafficking networks. And with that in mind, I would like to know what conclusions have been drawn by Sweden as to this problem. Reference has been made to some 2,000 minors who have allegedly disappeared, having arrived in Sweden. I await your confirmation or not of these figures, but that's a lot of missing minors. Have investigations been carried out as to the criminal dimension of this phenomenon as applicable, and the numbers of children who have been affected? This brings me to my last question under this cluster, issue 25, with regard to the rights of persons with disabilities. This has been divided into various subsections. Here, in view of the somewhat vague nature of the replies from the State Party in its report, elsewhere, I can say that your replies here are generally quite precise. Lots of these issues have been examined in very close detail by our sister committee, the Committee on the Rights of Persons with Disabilities, CRPD. But nonetheless, I might seek some minor clarifications. The distinguished head of delegation, first of all, raised the point concerning the new disability policy, which was underscored in your opening statement and which is to come online in 2017. Could you kindly expand on this disability policy? It's possible that this new policy might have arisen out of some concerns expressed by the CRPD. I await your confirmation of that. Can you tell me whether this new policy takes into account or seeks to improve various matters pertaining to accessibility? What measures are to be taken to facilitate accessibility? I'm thinking particularly of access to justice. This was a problem that was flagged up by the Committee on the Rights of Persons with Disabilities. This would involve inter alia, legal assistance or aid, also access to education and work. What is being done there? On the specific matter of employment, I find that the explanations given in paragraph 177 of the state's report are fairly comprehensive, but I would nonetheless be grateful if you could explain, since you have not really done so, why the rate of employment for persons with disabilities declined between 1998 and 2003, and why, according to information we've received, it is apparently at a historical low point of 44%. Why is it that despite the measures taken by the State Party over this period, the rate of employment amongst this group has decreased. This question comes in the light of what is said in paragraph 177 of your report, where you indicate that the number of persons acceding to facilitated subsidized jobs has increased. So how do you square these two figures, the increase in subsidized jobs and the historical low point in employment? In his opening statement, the minister also made reference to violence and abuse against women and children with disabilities, which have long been neglected.
Targeting violence against women and children shall always include the disability perspective.
How, in specific terms, is this perspective to be mainstreamed with focus on disability in preventing violence? What measures are being taken as part of this disability policy? I will not dwell on the issue of psychiatric detention because I believe that was mentioned yesterday. That was one of the questions I had in my mind, the potential use of detention solely on the basis of a disability. That question, I think, has been addressed already. Thank you, Chairman. Thank you, Mr. de Frouville.
I turn the floor to my colleague, Sir Nigel Rodley. Sir Nigel, you have the floor.
Thanks. I'm going to ask a couple of follow-up questions in relation to paragraphs issues 19 and 20. They'll be pretty brief, particularly reassured that there have been no returns to the use of diplomatic assurances for sending people to countries where they face serious threats to their fundamental human rights. I guess if 2001 was the last time, that's probably a reference to the Alziri case and the Agiza case before this committee and the Committee Against Torture, respectively. And it's excellent to know that we're no longer faced with any repeat of that. In paragraph 138, there is reference to the special system the Aliens Act, the Aliens Control Act, and what is not clear to me, and our question related particularly to the question of qualified security cases. And what is not clear to me from this paragraph, which may also fall into the paragraph 138, which may also fall into the category of less than extensive explanation of the issues, is how do the provisions relating to such cases, the security cases, differ from the other procedures? It's not clear to me how the procedures differ and why they're necessary, especially if they lead to if the same protections in terms of the ensuring against refoulement apply regardless of which system operates. Or is there maybe a dimension, and this would be very helpful to know in the security cases, may this then lead to a detention in a way that other cases of non-refoulement do not necessarily lead to detention? So could the system be unpacked and an explanation for why it's there, what it does, and what it achieves? In relation to issue number 20 and paragraph 139, the delegation didn't know the source of the information, we mentioned in issue 20, where we referred to 531 Iraqi nationals being allegedly forcibly repatriated to Iraq. The source of information was Amnesty International and the UN High Commissioner for Human Rights, at least as cited in the US Department of State annual human rights report. To the extent that the facts may not have been accurate, it's very helpful to have the clarified facts. There are substantial numbers of involuntary deportations. Obviously, voluntary deportations, as long as they're really voluntary, are not particularly of concern to the committee. As far as involuntary deportations are concerned, I would like to have a reaffirmation in this room from the delegation that in each and every case of those hundreds of people being involuntarily sent back to Iraq over the years, each has indeed been the subject of an individualized determination, as indicated in paragraph 139 of the response of the State Party, of the report of the State Party. And with that, again, I express my appreciation for all the very helpful information I've received so far, we've received so far from the delegation, and look forward to hearing their responses. Thank you, sir.
Thank you very much, Sir Nigel. Now I pass the floor to Mr. Fatala. Mr. Fatala, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, I will deal this morning with issues 22 and 23, and I will try to be brief. These two issues are related to the protection of minority groups. As for issue 22, hate speech against Muslims, Afro-Swedes, Roma, and Jews, the committee addressed the Swedish intention to raise the issue of hate speech online. No reply was provided in the Swedish reply except in a very marginal way in paragraphs 149 and 150 concerning the education material aiming at strengthening young people's resistance to xenophobic, anti-democratic and violent message on internet and in social media. Therefore, the committee would like to have more elaborate and comprehensive reply to this issue on how to address hate speech online. Comment on the measures taken to curb hate speech and hate crimes and their application throughout the country. The committee appreciates the measures taken by Swedes to curb hate speech and hate crime as described in paragraph 145 to 151 of the reply. We need further clarification related to did the hate crime groups referred to in paragraph 146 have been set up in the 3 metropolitan regions? Has the government revised the need of and forms for a national knowledge and resource center on racism, partly in order to spread the successful models that exist for reducing the recruitment of people to racist organizations, as stated in paragraph 151 of the report of Sweden. And finally, in accordance with the Swedish Crime Prevention Board, only 5% of all hate crimes that had been reported in 2013 had led to legal action as of April 2015. Please clarify this matter and the role of the Chancellor of Justice in this regard and how he dealt with these issues. Now I turn to issue 23. taking into consideration what was mentioned previously, what I just mentioned, please provide information on measures taken to ensure equal enjoyment of the right of freedom of religion and belief, Article 18 of the Covenant, and give example, for instance, about places of worship and how you deal with this issue. Efforts to elaborate on efforts to review school textbooks to prevent discrimination towards minority. And finally, whether Sweden intends to address the chronic negative portrayal in the media of members of the Muslim minority and what steps have been already taken or envisaged to be taken in order to address this issue. Thank you, Mr. Chair.
Thank you very much, Mr. Fatala. Now I turn the floor to Mr. Shani, last speaker on my list.
Thank you, Mr. President. Again, I thank the delegation for its answers, including this morning's answer. I have a very brief follow-up to the information provided by, I believe, Ms. Remeros on the vulnerable EU citizens. Just to make sure that I understand the conundrum, if I understood correctly, I mean, to be qualified as a Swedish resident for the purpose of obtaining social benefit, one would have to be expected to be more than 1 year in Sweden. And we have this population which de facto may be more than 1 year, or maybe even more than a longer period, but because under the EU arrangement they are only lawfully entitled to be 3 months in Sweden, the fact that they go in and out in a way cancels itself. So every time they go out of the country, they are treated and re-enter, they are treated as if they are newcomers for 3 months, and there is no, under the existing structure, there is no overall assessment of whether they are likely to be more than 1 year legally, because they are legally in the country for more than 1 year, but they're not considered to be legally in the country more than 1 year because they're going in and out. So I just want to make sure that I understand exactly you could say the regulatory situation. Now I want to dedicate my remaining intervention to issue number 24, which deals with indigenous peoples and most specifically with the Sami group in Sweden. I first want to again to acknowledge both the responses and also the steps that have been taken to amend the relevant legislation, and including to mention that group in the Constitution. And this is of course positive, but I do have some remaining issues which I want to raise. First, I would appreciate an update by the state parties delegation with regard to negotiations for the Nordic Sami Convention. It is our understanding that the negotiations were expected to reach conclusion in the coming weeks, and I would appreciate any update that you can provide us. And whether there is any intent in light of these negotiations, or regardless of these negotiations, to revisit the issue of the Sami bill, which has been, I understand, since 2009, the matter has been pretty much frozen. The second point I want to ask has to do with the duty to consult with representatives of the Sami people in connection with projects involving exploitation of natural resources. I would appreciate if the delegation could explain to us what is the scope of the duty to consult, and I insist on consultation, not just information, not just providing information, but actually consulting meaningfully with that group under both the 2009 National Minorities and Minority Languages Act and also under the recent 2014 amendment to the Mineral Ordinance. We do have, I'm asking this question because we did receive some concerns about the scope of the duty to consult. I also know that the legislation does have some, let's say, loopholes that enable the government to perhaps circumvent this requirement in certain cases. And I would also appreciate in that regard whether the government could address the claims that we have received with regard to inadequate compensation in specific cases in which the activities of mining operations had led to an adverse effect on the interests of Sami groups. I'm speaking specifically on Kiruna town, and the whole city was dislocated because of mining activity, and the whole town was dislocated, and there are concerns about the adequacy of the compensation. But I also have some other examples, Galok, Rondak, where there have been concerns about the treatment of Sami interests, the protection of Sami interests. Now, with respect to the Sami parliament, the main concern that we have has to do with, like other issues we've raised with regard to funding. There appears to be currently funding for one salary, full-time salary for the parliament, the assembly chair. And this point has been raised also by the Special Rapporteur on the Rights of Indigenous Peoples, that the current funding does not allow the body to operate in an independent and effective manner. Now, with respect to the Reindeer Husbandry Act, the question I have in this regard is more general, not so much about the specifics of the act, but rather whether the delegation agrees, and if so, whether it can explain that in general legislation confers stronger protections to Samis involved in reindeer husbandry than to Samis who are not involved in such reindeer husbandry, and what laws or what programs protect the interest of the latter group, of those who are not involved in reindeer husbandry. With respect to land rights, I also note with appreciation the position of the Swedish Supreme Court that recognize in principle that Sami traditional land use and occupation could give rise to property rights, but we understand that there are still remaining issues concerning the demarcation of the grazing areas that would give rise to land interest. And specifically, can you update us on the state of play of the 2006 report of the Boundary Commission, which was supposed to be implemented but has not been implemented so far? There are also concerns about the way court cases involving Sami land rights or interest are being addressed. I did not understand the position taken by the delegation in the replies to the list of issues in this regard, noting that legal aid can only be provided to individuals. If we are dealing with a serious issue which has a group right dimension, it's not clear to us why there couldn't be ways in which those group interests would be supported by legal aid to the extent that the interest of justice would require legal aid to be provided. I would note that there are also other concerns with respect to these legal proceedings, specifically with respect to the burden of proof and insistence upon the submission of written documents in a context where written documents are not readily available. Of course, this is not just a problem that arises in Sweden. This is a general problem of the need to accommodate within, one could say, Western legal procedures or concepts, traditional forms of proof of legal rights. So I would appreciate this delegation's position on this. And finally, on this issue, there have been some reports about calls for a truth commission that would investigate the way in which historically the Sami people have been treated. And there are also some remaining issues that have to do with preservation of cultural heritage, specifically reburial of certain cultural artifacts and certain skeletons and skulls that are on display on museums. So I understand that the government is considering this, and if you have any information that you can provide us about whether this is something which is seriously considered or whether any position has been taken on this. This would be very useful. So thank you very much for your information.
Thank you, Mr. Shani. Muy bien.
Very good. Now we've finished with our questions on the second part of the list of issues. So just as yesterday, we'll give the delegation a short time to organize their answers. So we will suspend until 11:50, and we'll then meet with the delegation again and hear their answers. Thank you.